everyone, and welcome to the Veterans Legal Lowdown. In our podcast, we bring together the experience and knowledge of some of the nation's leading veteran law practitioners. We're here today to talk about topics of concern for the veteran community and for their dependents and their loved ones. Please like, subscribe, comment, and share any of the content that we produce that you find helpful. If you're watching us on YouTube, just a reminder that you can find us on Spotify, Apple Podcasts, or wherever you get your podcasts. And if you're finding us as a podcast, you can also check out our YouTube channel. We'll have these podcast episodes there, as well as plenty of other videos and content that we hope you find useful. So let's get into it for today. We're going to do some quick introductions. My name is Maura Black. I'm a partner here at CCK Law. And in today's episode, we have a lot of pretty dense topics, but super helpful information. We'll be answering questions from the community about special monthly compensation and TDIU and more. We will give you some insight into how a law firm like ours approaches increased rating claims for orthopedic conditions. And we'll discuss some of the trickiest and most asked about topics in veterans law, including things like, can I get benefits for conditions caused by obesity if that obesity stems from my military service? What about special monthly compensation at the S rate versus the L rate? A lot of questions we get around there a lot of questions we get about SMC that we think could be helpful. And to help me out, probably most importantly of that whole intro, I'm joined today by Nick Scripter, an attorney here at CCK Law. Nick, can you tell us a little bit about yourself?
Yeah, sure. So my name's Nick. I have been with CCK for just about 5 years now. I guess 6 if you count my internship when I was finishing law school still. So been with here since I first became an attorney. So I work at our court practice. So whereas a lot of our team works on the agency side of things directly with VA, I work exclusively on appealing board decisions to the Court of Appeals for Veterans Claims. So that's a independent court. It's not a part of VA. It's really where we take things when we sort of hit an impasse, I guess you could say, on a client's appeal, and we just aren't seeing eye to eye with VA. That's where I come in and take it up and get a judge's decision on that.
Great. And I'm particularly glad that we have a core expert here with Nick. And my practice is primarily at the VA regional offices. So between myself and Nick, we have a lot of ground covered in terms of cases that we see at the regional offices as early as the initial claim stage, all the way up to an appeal at the U.S. Court of Appeals for veterans claims like Nick described, which is where you will sometimes end up if you have filed a claim and you've had to continuously pursue an appeal of denials over and over through the process at the agency and then to the board and then finally to the court. We want to first start off today by talking about extraschedular TDIU. This segment is going to be about what extraschedular TDIU is, and we want to clear up some of the reputation that surrounds extraschedular TDIU. I think the thinking is that this is a very difficult benefit to achieve. A lot of veterans are deterred from seeking TDIU if they feel like they don't meet the scheduler requirements, and I'm putting that in air quotes because they're not true requirements. So let's talk, Nick, about extraschedular TDIU. And before we do that, I want to first start off with just a primer on what TDIU is in general. So a TDIU is a total disability rating that's based on individual unemployability. And what that means is that if you are successful in proving to VA that you are unable to work due to your service-connected disability limitations, you can tap into a total rating benefit, but a rating that is based on your individual unemployability, and you do not have to demonstrate that you meet the scheduler criteria for a total rating. So a lot of veterans who have experience with combined disability ratings know that VA math can be a challenge, and it can be very difficult to get individual rating percentages and get them to add up to a 100% rating. TDIU is another way to get rated at a total rating for conditions that preclude your ability to obtain or maintain substantially gainful employment. Many veterans do not realize that extraschedular TDIU, as I alluded to before, is still a viable pathway to getting that total rating. A common misconception is that if a veteran does not have the individual ratings that meet the scheduler criteria that's set forth in the regulation that talks about TDIU, then they're somehow precluded from obtaining that benefit. We see this erroneously stated in VA decisions. We see VA really fixate on the scheduler criteria that a veteran has when analyzing TDIU. But the truth is that regardless of what your ratings are, there is a pathway to obtain TDIU if your service-connected disability limitations preclude your ability to obtain or maintain substantially gainful employment. So we'll talk a little bit more about what that all is, what that means. We've got a lot of other content on this too. Let's start, Nick, if I can ask you to talk about the difference between schedular and extraschedular TDIU.
Yeah, so the only real difference between schedular and extraschedular is found in VA's regulation. It's at section 4.16. Subsection A is where they talk about the schedular requirements, and then, which I'll go through in a minute. But then subsection B is where they basically just say, but even if you don't meet those requirements, we will still award TDIU if you can demonstrate, like you said, that you can't work due to your service-connected disabilities. So the schedular requirements in subsection A, you need to have either a single disability rated at 60%. And if you have that, then that's it. You meet the schedular requirements. Or you need to have at least one disability rated at 40% with a combined disability rating of 70%. So if you meet either of those two things, then that's all there is to it. You meet the schedular requirements for TDIU. And so then it's just a matter of the VA deciding whether or not it believes that you are entitled to TDIU. Extraschedular, again, on the other hand, even where those schedular ratings are not met, VA will still have to decide whether you are able to work or not due to your disabilities. There are some procedural changes that VA, or some different ways VA processes an extraschedular versus a schedular TDIU claim, but we'll get into that. Ultimately, it's going to be the same substantive focus, the same question of can you work? If you can't, is that due to your service-connected disabilities? So yeah, that's schedular versus extraschedular.
Okay, great. And we'll talk a little bit more, like you mentioned, there are more procedural hurdles to navigate if you are pursuing extraschedular TDIU. And just a couple of notes, because I know I said it before, but I'll say it again. VA commonly says that the schedular criteria in 4.16A, the regulation that governs TDIU, are schedular requirements. Talk a little bit more about that, because we see this all the time, I think, at the agency and at the court level. Yeah,
so veterans definitely can't be blamed for thinking that they are actual hard and fast requirements, because one, just the word requirement sounds like that's what it is. And also, a lot of times veterans are going to get an award of TDIU the date that they happen to meet the schedular requirements. And then, in that earlier time period where they don't yet meet the schedular requirements, they'll be denied. So, the fact that it just so happens to line up with the date that they they meet the schedular requirements, of course, you're going to connect the dots and think that that's why. Whether or not that should be the case is, kind of where I get involved, or our firm at large gets involved. But basically even if you don't meet that schedular requirement, VA is going to have to just answer the same substantive question, or the same narrow focus of what is your ability to work? What are the impairments associated with each of your individual disabilities, and how, when combined all together, the various disabilities that you may have, whether they preclude employment. The only divergence is that, at least right now, when you don't meet the schedular requirements, before they grant or before they make a final decision on
Mhm.
TDIU, they're going to send it to the director of compensation to make a recommendation, pretty much. And once that director makes their recommendation, then you have to get it back to the board to then determine if they will follow that recommendation. But again, we'll kind of get more into what that recommendation is and some cases that we're working on to try to change that process.
And I definitely want to talk a little bit more about the extra procedural step of the referral to the director of the compensation service, Nick, like you mentioned. And also there's a good amount of case law that helps to show that despite this extra procedural requirement, extraschedular TDIU is still something that VA needs to consider just as well in cases where the merit is there, despite the fact that those scheduler criteria are not met. I think there are a couple of cases that come to mind, Bowling v. Principe and also Wages v. McDonald's, that kind of safeguard a veteran's ability to be considered for extraschedular TDIU. Bowling talks about the importance of following the process, which the importance of following the process is kind of a double-edged sword. We'll get to that later. But the importance of referring a case to the director if a veteran does not meet the scheduler criteria for consideration of schedular TDIU, but does otherwise demonstrate that they have service-related impairments that preclude the ability to work in a substantially gainful capacity. And Wages also talks very significantly, I think, and this was a CCK case, I believe. Wages talks about how an opinion from the director of the compensation service is not actually evidence in a case. So it's a relevant step, and it's a step that's defined in the regulation that VA has to obtain this opinion or this recommendation from the director as to whether extraschedular TDIU can be granted. But then if that case is being heard at the board, that opinion is not evidence.
Yeah, and I think so. It's a sort of weird little, whether it was a feature or a bug, I'm not quite sure, but regardless, we're left with the situation where the board is remanding the issue of TDIU to the director for their opinion, which can take months or even years before you finally get that opinion and get it back to the board. But then what that opinion amounts to is just, legally speaking, not a lot, which is good if they recommend not awarding TDIU. The board still has to go through the analysis, and if the evidence is there, if the merit is there, should still grant. But then if the director recommends it, the board doesn't necessarily have to follow that recommendation. But that is kind of what leads us to this ongoing case, which a case that we are actually arguing right now, Witkowski v. Collins. So our colleague April Donahauer recently had the oral argument in this case. We're waiting for a judge's decision now, or a decision from the panel of the judges. But in that case, we're basically making the pitch that there is no need for the board to remand it to the director for an opinion. The board should do the analysis on its own and grant TDIU if, of course, if it believes it's warranted, if the evidence is there. But the reason we want to get the judges to say the board doesn't have to do this is so that we can kind of cut out the middleman there in these extraschedular cases, because that really is the only true difference between scheduler and extraschedular. Extraschedular TDIU cases are more than viable, but there is sort of that hurdle of that extra time it's just inevitably going to take. So, when you have us repping you for TDIU, we'll be able to handle all of that. But whether you have an attorney or not, it's going to take a long time for an extraschedular case to go through, or even longer than a schedular one. And that can be a problem. Obviously a lot of our clients, a lot of veterans are really dependent on this, and back pay in the future will be great, but it doesn't help right now. So we'll see what happens in that case. If we don't get the outcome we want there, it'll mean status quo. So still, again, viable, still something that can definitely be pursued. But if we are able to get a good outcome there, then that just means the difference between Extraschedular and Schedular just got smaller than it already is. So stay tuned on that. But
that's a great point. So, and I realize that this is a little bit confusing because I think we have this regulation that says that Extraschedular TDIU requires this added step to get a recommendation from the director of VA's compensation service. And yet the output of that effort is something that case law says is not evidence. Oftentimes these recommendations are negative, as Nick mentioned, so they don't help a veteran. In fact, it's just another voice in the room saying this veteran should not get TDIU. And so, as Nick was discussing with our efforts in Witkowski, that we are watching very closely and hoping for a good result there, we are trying to sidestep that referral. If we are representing a claimant who has a good case for TDIU, who has service-connected issues that prevent their ability to work, but they don't meet those scheduler thresholds that are outlined in the regulation, we would like the option to be able to waive the step of going to the director. We would like there to be some choice at VA's level to say that this added step will not help to substantiate the veteran's case for TDIU, which is the whole sort of purpose of getting that development in the first place.
Right. And that's sort of like it. We're not going to get too much into this legal concept of prejudice, but even if you have a regulation saying, oh, it's to safeguard the veterans, VA should do this, if the board can go ahead and say, well, even without doing that, we can give them the entire grant of benefits that they're looking for. It doesn't harm the veteran that they didn't follow this regulation. In fact, it helped them that they didn't do so. So yeah, we'll see how the court weighs in on that. But
exactly.
But yeah, ultimately, I think just the takeaway from this is that Extraschedular TDIU is more than a viable path if your combined ratings don't hit those scheduler requirements. This might be more of an extreme, like outlier example, but I actually had a case once where I was arguing that it wasn't a client at the agency level of ours, but I was representing her for her court appeal. And I successfully argued that TDIU had been reasonably raised Extraschedular TDIU, where the only service-connected disability was a wrist condition rated at 10%. So, in that particular case, there was evidence showing that they weren't able to perform the jobs that they had done prior, which involved a lot of typing. So just kind of an extreme example, again, of even at just that 10%, TDIU was very much on the table there. So,
and that's a great example though, Nick, because as much of an outlier as it may be, it's important to note, and from our perspective, we've got about 20 to 25% of our CCK cases where we're pursuing TDIU, where the veteran falls under the Extraschedular part of the regulation. And that's no small portion of our case inventory where we're pursuing Extraschedular TDIU. And what it comes down to, that you mentioned in the case that you highlighted, is what does the evidence say about the person's ability to work given their service-connected limitations? And regardless of this extra procedural step in the regulation and the work that we're doing to try to sidestep that to effectuate faster decisions and to mitigate delays that can come from the referral to the director process, at the core of what we're doing in every TDIU case is still pretty much the same. We're developing evidence that shows that we meet the legal standard of this client's service-connected conditions preclude their ability to find work and to keep work, and not just any work, but substantially gainful work. And so how do we go about doing that? We've talked about this in a lot of other areas. Solid lay evidence and medical evidence that speaks to the functional limitations that are caused by service-connected disabilities. Vocational evidence in particular can be very important to have a qualified vocational counselor say, I work with people to try to get them rehabbed for work or to get them to be employable. And I'm seeing these limitations as those that would preclude this veteran from performing work in a substantially gainful capacity. I mentioned medical records, but those can be very helpful too, especially for VA. VA does tend to rely on their own VA treatment records and compensation and pension exams. So what facts from those exams and treatment records can we glean that speaks to the person's inability to work because of service-related conditions? If it's just a 10% disabling wrist condition, you could think of a lot of different areas where that would impede even sedentary work, like typing and lifting files and things like that. So it's definitely important to be working with a representative on a TDIU case, particularly if it's an extraschedular case, because I think VA is not inclined to grant those as easily. They've got to go through this mess of a process in the regulation. And they also kind of look at these cases as, well, these are lower ratings, so maybe the functional impact isn't there. But those are cases with which we have a ton of experience. And we know that it's not always the case just by looking at the ratings. And that's why the regulation talks about these different pathways, because even a veteran with a 10% for a wrist is still entitled to pursue TDIU.
Yeah. The assumption that lower ratings equate to lower impairment, again, I'm not going to say that that's not true at all, or just the impairments, the rating schedules are meant to be averages. And then TDIU is meant to fill the gaps where, on average, a wrist condition may only be 10%, may only impair you 10%. But if your career has been built on something that requires extensive use of your wrist, again, just to keep using that example, you are going to fall outside of the average for that. So it's really just a fact-dependent thing. You have to look at your own case and think, what are the reasons I can't work? And if you can't work due to things attributed to your service-connected conditions, forget about your ratings and, make that TDIU claim or make that TDIU assertion and, let your representative take it from there if you have one.
Exactly. Great. And then the final thing I will say about extraschedular TDIU, a little bit repetitive, we are going to provide an update once we hear more about what's happening in Witkowski. Another piece that you mentioned, Nick, that's really at the heart of that legal matter is trying to help veterans sidestep any delays in the process that don't serve them, that don't help to get evidence into their file that substantiates their claims. This is a super important concern that veterans have, is how to navigate the process in a way that is efficient, productive, and not a super long wait time. And so that's one of our many goals in pursuing that case. So more updates to come. We thought we would now take some questions that we've gotten, but questions that are specific about cues or clear and unmistakable errors. So this will be something of a Q&A segment. Nick and I are going to be talking about questions around what is clear and unmistakable error, how it works, and how to navigate the process if you are pursuing a benefit that stems from what you believe an error was made in the past, a clear and unmistakable error in an adjudication. This is, disclaimer, one of the most technical, very high standards and burdens area of VA law. Cues are very rare. We don't see them a ton. Nick can talk more because I think he probably sees more than I do at the court. But these are very, very discrete mistakes that have been made in the past. They're not impossible to prove, but they're very, very difficult to prove.
Yeah, I think if the rest of the VA system is, in theory, supposed to be accessible to laypersons, to non-attorneys, Q is difficult for us. So, Godspeed if you want to file a Q. I don't mean to dissuade anybody from thinking that they're not possible, but yeah, we'll get into it. It's very possible. It's just very technical, and there will be things that, just to your mind, you're like, well, this was clearly a mistake. Obviously, this was wrong, and you might be right, but that doesn't mean it hits those technical legal markers for Q. So that's kind of what we'll get into about with these questions here.
Exactly. So first question that will help us kind of explain what Q is a little bit more. What are some common examples of Q, and what are some examples of cases that are not clear and unmistakable error? So the example that comes to my mind is an example where a decision is made based on facts that were not existent or just completely not as the adjudicator presented them to be in the decision. So in order to demonstrate that a Q was made, You have to prove that adjudicators did not comport with facts as they were clearly known, or apply the law as it existed at the time of the decision. And these are things about which reasonable minds cannot differ. There can be no question. There can be no one person sees it one way, another adjudicator might have seen it another way. Those are instances where Q doesn't exist. Where a Q might exist is if we see a rating decision and it says that a veteran's claim for service connection for a mental health condition cannot be approved because there was no evidence of in-service treatment for a mental health condition. If the records show that the adjudicator had at that time that there was in-service treatment notes of a mental health condition, then that might be a clearly an unmistakable error, because the facts as they were in the record, in writing for everyone to see, were not adhered to, or the decision that the adjudicator rendered was not based on those facts.
Yeah, and contrast that with a case where, or the same case, but instead the regional office acknowledges the in-service treatment, but says that they don't think that that showed sufficiently severe symptoms or whatever their rationale might be. But the fact that they addressed it and weighed the evidence, that's where we leave Q behind. And you're just not going to win on a Q motion in an instance like that. But right, in your example where it's clearly factually incorrect when they said that there was nothing in the service records, that would be Q.
Exactly. Nick, what about time limits to file a Q? Talk a little bit about that.
So, short, easy answer, there are none. That is sort of, I think, one of the gaps Q is meant to fill. Normally, you have your 1 year to appeal a negative decision if you'd like to, and after that, you just have to go ahead and file a new claim. Q, though, there is no time limit. You could have a decision from 1975, right after you got out of service, and if you think that there's Q in it, you can file a Q motion 50 years later in 2025, and if you're correct, then you'll still be able to get that retroactively corrected. So, in short, no time limit.
And another thing that's pretty liberating about Qs, for all the difficulty that they pose, filing a Q motion, and we call it a Q motion because the procedural mechanism by which to raise a clear and unmistakable error is to file a motion for revision of that decision that contains the error based on Q. So what you're doing is you're telling VA, you need to revise this prior decision that you made, regardless of how long ago it was made, like Nick described. You need to revise that decision and remove this clearly and unmistakably erroneous determination. So to do that, you do not have to file a specific form. And that's going to have an asterisk after that, because I'll tell you what we do here. There is no form to file a Q motion. I think anyone who's in the VA process now knows that everything has a form that goes with it. In order to file for TDIU, you need to file the 8940. In order to file an appeal, it has to be on a correct form, and legacy versus AMA. So forms are everything. And there is no form for a Q motion, which is good. That said, one of the things that we try to do is to file a Q motion with a claim form. This is not correct. We do this because we want VA to establish what's called an end product in their systems to adjudicate the motion for Q. So we have found that if you just submit a letter that explains, I think there was a Q in this decision, it's possible that it might get sort of like lost in the mail, in the sense that VA will not establish a task for their adjudicators to complete and work without a form.
Yeah, especially these days now that there are strict form requirements.
Exactly.
Back in the day, if you sent a letter in, VA was supposed to read that letter and determine what it was. Now that they don't do that with claims, I think sending some sort of form like what we do, even though it's not strictly necessary, sometimes just playing by their rules, so to speak, can just help get the ball rolling more than just sending in any piece of paper with your assertions on it.
It's kind of like bait. Send the claim form, and then there's a better chance that someone will stop and figure out what needs to be done with this.
Right.
So we've gotten questions, do I have to file it on a certain form? The answer is no. But if you're noticing that you're sending in correspondence to VA and they're not picking up on it, you may want to consider a 526 EZ or even an 0995, the supplemental claim form, so that they create a tasker on their end to adjudicate the Q.
Another common question is, can I include any new evidence when filing a Q motion? And, generally, what should I file or include with that motion? So the answer regarding new evidence is no. What you should be submitting with your Q motion is arguments. One of the more technical aspects of Q motions are an actual strict pleadings requirement. So you need to identify the error that you believe is clear and unmistakable and tell VA what that error was and why it was an error, as opposed to just generally, if you think your shoulder is related to service, you can tell VA that, and it's kind of then on them to go through and figure out, okay, is there anything in the records supporting that? With Q, you need to walk them there. So definitely should be submitting arguments explaining that. But if you find yourself trying to submit or point to new evidence that wasn't in the file at the time of that decision, that should raise a flag that this might not be a Q case or that you may not be successful in it. So again, there's no time limit, but if you are dealing with a 1975 rating decision, you're probably going to have to just focus on, what was in your service records in front of VA at that time, as opposed to, some treatment records from the 90s that further elucidate the condition and its onset. Those may be helpful, just generally speaking, for establishing service connection. But if you're pointing to something that wasn't in front of the adjudicator at the time, it's going to be hard to say that they made a clear and unmistakable error since they didn't have the benefit of that evidence.
Exactly. And this comes up a lot with diagnoses that are rendered later in time. In many contexts, the lack of treatment isn't negative evidence against a veteran's claim. They can supplement that lack of treatment with lay statements and things like that. But if you're looking at a decision that was issued in the past and there were no treatment notes prior to that decision, and the decision was about, let's say, an ankle, and there was just nothing at all speaking to an ankle condition, it's totally understandable that maybe a veteran's story would be, I wasn't actively treating at that time, and that's why there's no documentation. That totally makes sense. It's just that kind of absence of evidence is not going to give rise to a Q. Nick mentioned before, this is sort of like the purpose of Q is to hold the agency accountable for very, very clear and obvious errors. But the agency can't be held accountable for what it didn't have at the time of the decision. In many cases, if evidence comes into the file later, it might show that something existed at the time of the decision, but it has to be very, very clear. No reasonable minds can differ about whether the evidence was there or whether the law was applied correctly. So that's going to be that added burden to get to the Q standard. Some have asked, how do I know which law or regulation VA did or did not apply correctly at the time of a decision? If you are struggling to figure out what law or regulation applies to your claim, there's a couple of places that you can look on your own, even if you don't have any experience in the law in this area. You can look at the list of regulations or laws that are listed in your VA decision. These are not always listed clearly, but oftentimes in a rating decision from the agency and certainly from a board decision, there will be a list of laws or regulations considered in making the decision. So you want to look at those and make sure that they were properly applied in your case. You can also find VA's laws and regulations right online just by searching for them. So you want to have the specific section that you think applies to your case. And then also it's good to remember that you're probably going to be looking at Title 38 of the Code of Federal Regulations. That's where VA's regulations lie. And we'll move on to a couple of hypotheticals because I think in the Q context, the hypos are the most common questions that we see. One that we've seen before is if I'm eligible for SMC-S, which is a special monthly compensation benefit, and VA issues a decision that does not grant it, does that count as a Q even though I didn't apply for SMC-S? Short answer is going to be no. There's no clearly erroneous decision made in this context. VA does have a duty to address things that are raised implicitly by a claimant, but in a case where an SMC benefit isn't claimed at all, it's going to be pretty much nearly impossible, I would think, to say that VA clearly erred in not addressing that which was not raised.
Yeah, sort of like duty to assist errors, reasonably raised things. VA may have been wrong in not addressing something that was reasonably raised by the record, but that falls in that gray area where VA is wrong, but they are not clearly and unmistakably wrong. So yeah, if you didn't specifically raise it, Q's probably not going to work out for you there.
And that is a great point that leads to another question we've seen. I believe that VA failed in its duty to assist on one of my claims. My other claims were sufficient to get me a total rating, so I didn't appeal that decision.
Right.
If I were to be reduced for some reason, could I then file a Q and get back pay on that reduction? So I think what's being described here is there was a duty to assist error with respect to a compensation and pension examination. The examination was flawed, and VA relied on that examination to reduce a veteran's rating. The veteran might later want to address that reduction if their P&T status is jeopardized in any way. And the question is, can they do that with Q?
So yeah, with Q, no. Again, it's one of those tough, we see this a lot where a veteran, they have their 100% rating and, naturally may just think, well, there's nothing more to do here. Oh, they denied that, but that doesn't really matter. This does raise the idea of like these kind of protective measures, which is really what we do a lot of as well. Even though this may not get our client additional benefits right in this moment here, it can just help protect them going forward. So here, yeah, where questions of whether a VA examination were adequate or, if VA did not get an examination, but you believe they should have, those are all going to fall under what we call like kind of those duty to assist questions. And those are just never going to be Q. So that's why it's really important when you're dealing with reasonably raised stuff or duty to assist questions, get that appeal in, whether it's a supplemental claim or board appeal or whatever it is. If you think that there was something done wrong there, appeal it within that year, because once that year is up, you're going to lose out on your ability to challenge that.
Totally right. And I think rating reductions are interesting in the Q context because, yes, it is totally right that a duty to assist error on its own is not going to give rise to a clear and unmistakable error. You may consider in a rating reduction scenario, did VA properly apply the law as it existed at the time to the reduction? Because that's an area where we see VA making pretty clear errors. Rating reductions require significant improvement or some degree of improvement in order for the reduction to proceed. And sometimes there can be an argument there that it was clearly and unmistakably wrong for the agency to decide that that improvement had been noted. But as Nick mentioned, if the improvement is noted in an exam, even if that exam is bad or the examiner wasn't paying attention to you or a lot of things that can happen in the exam process, totally valid. Those things are just not going to rise to the level of clear and unmistakable error because those are still facts in the record.
Right.
Negative facts don't absolve the agency of, this requirement to like read in between the lines or anything like that.
Yeah. But yeah, the point about reductions, even if it's not, again, to not get too legalese or technical, but even if a reduction doesn't invoke Q, it's another super highly technical area of the law. So, Q should raise your flag, go talk to somebody, try to help figure things out. Reductions as well, for sure. Because again, even if it's not going to be necessarily Q, there's still a lot of ways to get reductions reversed and have them restored even without it. But again, a lot of times that does have to be done within the year.
Okay, a couple more. And we touched on this, but this is a very common one, so it's worth repeating. My examiner disagreed with my diagnosis, even though I had strong evidence from outside doctors. Could this qualify as Q? No, because reasonable minds could differ about the import of all of that medical evidence. So this is a classic case of VA's doctors say no diagnosis. You may obtain private information that says, we disagree. This veteran does have a diagnosis. If the agency denies that claim, it is not a clear and unmistakable error for them to do that. That is something, to Nick's point earlier, that would be great to appeal. Yeah. And that's why you really want to pay attention to your 1-year appeal deadlines. And if you get a decision that sides with the wrong doctors, let's say, in that scenario, you really want to be timely appealing so that you're not limited to making a Q argument.
Yeah. And this fact pattern here where you have, your doctor saying something and VA doctor saying something else, those can be super frustrating. And I've talked with clients where they've been trying to get, maybe I'm working on a 2020 claim of theirs, but they also had a 2010 claim and they want it back to 2010. And, I can see how frustrating it would be when, your doctor has this 5-page report talking about how your condition is diagnosed as this and it's related to service. And then, there's a couple sentences from the VA examiner and VA goes with that one instead and denies. And, your brain may just be screaming, this is so wrong. This is, clearly my condition is related to service. And you're right. But again, it's just when you're talking about doctors disagreeing with each other and VA determining which of those doctors' opinions it's going to go with, that's weighing facts that just, you need to appeal that within a year. So, yeah.
It's heartbreaking. This kind of situation is really, really trying.
Yeah. So the lesson is appeal it within a year.
Exactly.
Appeal it within a year. And then Q is just this kind of like last backstop for when there was just really no way around it. But
totally. And final question along those lines. If my Q motion is denied, can I appeal that denial? What do you think?
Yep. Yeah. So just like anything else, VA's decision on a Q motion is a decision. It's an appealable decision, just like everything else. So that's, when we don't get too many of them even at the court level, but we only get them at court because somebody appealed that decision. If you file for Q, appeal it. Or if VA denies your Q motion, appeal it. If you get a board decision denying your Q motion, I'll be happy to take a look at it and do what I can. But it is definitely appealable.
And when you appeal, you're back to forms world. So even though you don't have to file a specific form, but we talked about that, to get the Q considered, once you get a VA decision on the Q, then you're back to needing to pay attention to the 1-year appeal deadline and the appeal forms that you need to file to be able to continuously pursue the benefits that were denied. Great. Thanks, Nick. We will pivot now to talking about increased rating for ortho issues. We wanted to talk about this because we've got representation here from someone who practices before the agency and someone who practices before the U.S. Court of Appeals for Veterans Claims. And we do a lot of work, both before the regional offices and the court, on our orthopedic claims and appeals, and specifically in the increased rating context. There are tons of regulations and tons of cases. We're going to go through like the tip of the iceberg today. More than that, we're going to try to get this to be as comprehensive as possible, but there's no way we can do all of it. But CCK does have a very long history of being on the cutting edge of these kinds of issues, rating conditions that affect the orthopedic system. Those are complicated cases, and we're hoping that we can demystify some of what that process is. So it's true that VA disability claims and appeals should be fileable and appealable by individuals working on their own. But what we're going to be talking about next, getting increased ratings for orthopedic conditions, the reality is that these are pretty tricky claims. Practically speaking, the complexity and the scale of trying to get a proper rating for an orthopedic condition is large and pretty daunting. There are a lot of regulations that guide adjudicators in what to consider and what to look for in rating an orthopedic condition. We'll talk about this, but while VA's regulations are written very much in terms of range of motion, which is usually only detectable with testing and examination, there are a ton of other regulations alongside those rules that talk about the import of limiting pain and painful motion and the differences between active and passive motion and things like that. So we're going to talk today about some of the applicable laws and regulations, some policies, and some court cases, including a bunch of CCK homegrown precedent-setting cases that have helped interpret the complex issues that can come up in increased rating for orthopedic condition cases. This is why VA-accredited lawyers do exist. This is why we are sharing this information, because this stuff is not easy. If you are battling one of these types of cases on your own, consider calling an advocate to help. Hopefully we give enough help today that people find this process more navigable, but don't beat yourself up if you're finding this tricky. This stuff took a while for us to learn. So Nick, why don't you give us some context, just kind of generally, what's an increased rating for ortho case like? What are the things that you think about?
Yeah. So as the name suggests, increased rating for ortho, I might refer to it as IR ortho. That's what I'm talking about. Just anything dealing with the bones, muscles, nerves, joints generally. So whether it's your ankle, elbow, knees, your back is obviously a big one. Scars as well. I feel like maybe at the court level, I deal less with scars, but backs, knees, all of that falls under ortho. And really, it's sort of the second piece of the puzzle when you're dealing with your service-connected disabilities. The first is getting them service-connected, and that can be a challenge in and of itself. But once you get that, you get to then make sure you have the proper rating. And that can either be disagreeing with the initial rating they give you, or sometime in the future, filing for an increased rating claim, if it gets worse over time, which, obviously is just common that over a 5, 10, 20-year period since you first got it rated, it, could deteriorate. So that's what we're generally talking about with IR ortho claims. And yeah, VA just on this topic alone has dozens of regulations, and there are court cases going back almost 40 years at this point. So we're all still trying to figure it out. It's more complex than it might seem on the surface.
For sure. And common, because as Nick mentioned, orthopedic conditions are typically progressively worsening over time. So a lot of individuals that we work with who have a diagnosis of a back condition, maybe when they're a 30-year-old just out of service veteran, that person is probably in for decades of potential increased rating claims based on the natural progression and deterioration of the joint or the affected area. So some of the regulations that come to mind, and there are many, we've got 4.40 that talks about functional loss. It defines disabilities of the musculoskeletal system as primarily the inability to perform the normal working movements of the body. And I would say this regulation is a clue to us that VA cares about compensating the degree to which joints have deteriorated and are not working and moving properly. There's also 4.45 that talks more about the joints. It gives a laundry list of things that VA has to consider when rating joint conditions, like whether movement in the joint is more, less than what you want, weakened, painful, excess fatigability in the joint. Does it cause incoordination of movement? Is there pain on movement? There's 4.56 and 4.73, which talk about evaluation of muscle disabilities and ratings for muscle conditions, respectively. There's 4.59 that we'll talk about later that talks about painful motion, specifically the intention to recognize actually painful, unstable, or malaligned joints as at least minimally compensable. It sounds repetitive, but all of this kind of gets to the point that VA's rating schedule is meant to compensate impairment in earning capacity, and conditions of the musculoskeletal system or of the joints are typically, like the hallmark cases of those things are functional impact that VA wants to compensate depending on the severity of those conditions.
Yeah, and I think a lot of the complexity in these cases arrives from sort of, it can be VA's general interpretation or goal is to, compensate for functional impairment. VA's regulations show that when it comes to these orthopedic conditions, they view that primarily through the lens of restricted motion. And of course, if you do have restricted motion, that is going to cause impairments. But what so many of these regulations, the ones you were just talking about, and so many of the court cases that we'll get into are focused on is figuring out what functional loss or the functional equivalent to loss of motion is. So, any veteran who's gone to a C&P exam for their back or their knee, knows that they're going to be run through the range of motion testing requirements. But the reality is you'll have a lot of veterans who, you may have arthritis in your knee, but you may also just have full range of motion. But then while it's moving, it may be very painful. It may just feel weak. It may, after a long day of walking around, just feel way more sore and tired than, it otherwise would have. So VA has acknowledged that, there are ways in which you can lose function as if it were, or at the same level as if it were actually restricted, the range of motion, but figuring out how to apply that in practice and get somebody the rating that accurately, captures their disability is, just where the tricky part is. So to dive a little bit deeper into a couple of the regulations there, Section 4.40 is kind of the seminal baseline functional loss regulation. And had some highlights on here. I just want to pull out the exact language. So to pull the language from the regulation itself, VA defines, disability of a musculoskeletal system as the inability to perform the normal working movements of the body with normal excursion, strength, speed, coordination, and endurance. So again, those are all factors that even if you are able to move your knee through the full range of motion, can you do it with the regular strength, the regular excursion? Can you keep it up for as long as somebody without a disability might be able to? And if you can't, that's what you should be compensated for, notwithstanding the mechanical range of motion. Section 4.45, it's titled the joints, and it kind of goes through the factors that VA is supposed to consider, again, beyond just range of motion. So they do have less movement than normal in subsection A. Subsection B, more movement than normal. As you alluded to, that can be more in cases where, a healed injury causes malunion or non-union of the knee or the tibia, kind of where it causes instability. Like I said before, weakened movement, excess fatigability, incoordination, so the impaired ability to execute skilled movements, and then last but not least, pain on movement. So pain on movement is another big thing that the regulations deal with, that that the court that I work in front of has been dealing with going back to the 90s. And what do you know? VA has a regulation titled Painful Motion, Section 4.59. And again, I just want to pull the actual language from the quote. Section 4.59, which is titled Painful Motion, talks about what VA or how VA should look at and rate pain. Again, notwithstanding the actual range of motion present. They say in their regulation that a joint that becomes painful on movement must be treated as seriously disabled. And here in this regulation, they note that when you have pain on movement, you should be entitled to at least the minimum compensable rating for that joint. So even if you don't meet the range of motion requirements for a 10% for your knee, if it hurts while you're moving your knee, you should still have a 10% rating for it. So it's something to keep in mind, where if you get service connected granted for your knee, great, and they award a 0%, just ask yourself, like, well, does my knee hurt? Presumably it does to some degree, because that's why you had some problems with it. If it hurts, you should file an appeal there and try to get at least that 10% rating. Again, that's just from section 4.59 there. So those are just a couple of the more important ones that come up in, in our work.
Great. And I think I would bet that there are people listening who are wondering why these regulations talk about things like painful motion, incoordination, inability to move with normal speed and excursion. That experience, or those factors, I should say, are not always the experience that veterans have when they go into an exam for an ortho condition when they're pursuing an increased rating. So if you have been to an exam and you're pursuing an increased rating for a painful joint, you do experience a lot of the things that Nick and I are talking about, more or less movement because of malunion of joints or an inability to get around with normal speed. It can be hard to understand why VA's focus in the exam is so very much on range of motion. So we recognize that these regulations and the cases that we're about to talk about are not always the focus in that exam room. In the exam room, it's all about the measurements of how much flexion, extension, abduction, et cetera, the joint is able to achieve, because that comports with VA's rating schedule. All of these regulations and cases, and I'd be curious for Nick's take on this, the way that I see them is that these contextualize and can really help people pursuing an increased rating because, as Nick mentioned before, when you show up to an exam and you're taking range of motion measurements that are supposed to represent how severe your disability has been for years sometimes, so many different factors can be present on the day of the examination. You might be rested or you might not be rested. You may have taken Advil that day or not. You may have had a really strenuous day the day before, or maybe you rested the day before. So the way that you're showing up to the exam can be different, and that can really influence range of motion measurements. So I say that because, number one, I think it's important to set expectations. People that are pursuing increased ratings for ortho conditions and joints, there's going to be a ton of emphasis on range of motion, and that's right. But there are also these rules that exist alongside range of motion measurements that are meant to better flesh out the degree to which the condition is functionally disabling.
Yeah. And so I'll start diving into some of the case law now. But I think, as we go through the cases, what is best to keep in mind is that, the court here, the judges don't just pull requirements out of thin air and, say, oh, well, VA needs to do this and VA needs to do that. On paper, VA has these regulations that say we need to look beyond just range of motion. It's just that, the court comes in to reconcile what it's supposed to do on paper and what it actually does in the exam room there and in, their office after looking at the exam report. Yep. So yeah, it's really just, all of these court cases are really just pulling from VA's own regulations, what VA says they are supposed to do, and just, guides them towards doing it.
Exactly.
So this has been going on since pretty much the court began. Our first case here in 1991, Shafrath v. Derwinski. This was the first time that the court said that sections 4.40 and 4.45, the ones that we were just going through, those make clear that pain must be considered capable of producing compensable disability of the joints. So again, it kind of sounds like the court is just saying what the regulations say, which is kind of my life on the court practice. Well, why do we need a decision on this? But, to give everyone, their credit, there's a lot of regulations and they're pretty complex just diving into them. So that was just the court's first acknowledgement of, VA's need to look beyond pure range of motion. DeLuca v. Brown was another big one, that we'll still rely on a lot. The court held there that, a vet can be entitled to a higher rating if he has either the actual range of motion restrictions or to the functional equivalent. And that functional equivalent language kind of really gets to the heart of what the purpose of the rating schedule is.
Mhm.
Impairment. Impairment can be shown through actual limitation of range of motion, but it can also be shown through other symptoms, other manifestations that we've been talking about. So those cases back in the 90s sort of set the stage for what would still be, decades more of litigation, but yeah, really just set the stage for what would come later.
Mm-hmm. And another important turning point in the case law, from what I remember back in my court days at least, is Mitchell v. Shinseki from 2011. And this sounds a little bit confusing, but hopefully we can break it down. A major part of the holding from that case is that although pain may cause functional loss, pain itself does not constitute functional loss. And the case goes on to say how important it is if a veteran is experiencing functional loss due to pain on examination, the examiner has to indicate where on range of motion testing that pain began. So this kind of goes back to the need to blend range of motion testing results, but also the subjective and other experiences the veteran is having due to pain and the functional limitations caused therein. So Nick kind of described this earlier. The veteran who is experiencing pain at the very end ranges of motion is, for VA purposes, very generally speaking, perhaps not as disabled as the veteran whose pain begins with just the slightest movement of the joint. And so needing to consider that for compensation purposes is important. Yeah,
and it's almost every single orthopedic exam that I look at when I'm dealing with these cases. It will say that. It will say, okay, veteran has full range of motion. The examiner will also note, though, that he has pain, and they will note that the pain causes functional loss. And, that's great for me to know that pain causes functional loss in this particular veteran, but I need to know where. Like you said, if you only start to experience pain at the very, very end of the range of motion, then, per VA, you're not going to be as impaired as if the second you start moving your knee, it's just excruciating pain. Right. You can do it, but it's just excruciating. So kind of telling me that there's functional loss from pain, it doesn't tell me. And if it doesn't tell me, it doesn't tell the adjudicator at VA what actual degree of impairment you had. So we use that case a lot to try to, get it sent back for an examination that's really going to tell the board where the board or the regional office where that pain begins. Exactly.
And pivoting a little bit, but back to what we were talking about earlier with 4.59, we have the case of Petiti versus McDonald's. This is from 2015, a CCK Law case. And it finds that the terms painful motion and actually painful joints, when reading 4.59 and one of the diagnostic codes for orthopedic conditions, those two phrases are synonymous, and the court could not conceive of a situation in which an actually painful joint would not necessarily connote a joint that was painful on motion. In other words, pain itself is compensable for VA disability purposes. And exactly what Nick was describing earlier, there might be full functional performance of the joint, but still pain existing. We need to compensate that pain somehow. The veteran who has pain but is able to move the joint in a full range of motion is still disabled to some degree because of that pain. And so this case helps to reinforce that.
Another one from around the same time, I believe, Correa v. McDonald. Again, that's dealing with section 4.59, and part of that regulation, which I don't think we specifically talked about earlier, but part of that regulation says that when a veteran goes in for an examination, they need to have range of motion testing done both on active and passive motion. So active would be, moving the joint yourself just as you would in daily life. Passive can be, like the examiner going and moving it for you, but also in weight bearing and non-weight bearing. So again, you may be able to move your knee a good amount when you're sitting down and, there's no weight on it. But then when it goes to climbing the stairs or just walking, down the street and you're putting all that weight on your knee, that may be where you have the functional impairment. And again, nobody gets to walk around without putting weight on their knees. So if that's the case, we want that to be compensated for.
Mm-hmm.
So in the case Correa here, the court noted that regulation requires these range of motion testing, and they saw that the examiner reports that were in front of it just did not have that testing. They may say, oh, there was pain on weight bearing, but kind of like Mitchell, how much pain, how does it affect the range of motion there? Is their range of motion reduced? If it's not mechanically reduced, where does the pain begin while they're bearing weight?
Mm-hmm.
The same trend of just trying to draw out this information that all these regulations say VA needs, just kind of like tackling it piecemeal, getting each aspect of it pulled out. Southall Norman v. McDonald was another case shortly after Correa. But basically there, the Secretary of VA had argued that the section 4.59 about those testing requirements and about how painful motion should get you that minimum compensable rating. They had argued that it did not apply to diagnostic codes where range of motion was not implicated. Most orthopedic diagnostic codes, again, do have some sort of range of motion component to them. Not all of them, though. In this case, it was the diagnostic code for foot disability. So they argued that because it wasn't based on range of motion at all, that painful motion should not warrant a compensable 10% rating. But the court there said that the plain language of the regulation did not limit it to just range of motion based diagnostic codes. So even if you're dealing with a disability an orthopedic disability that doesn't have a range of motion requirement, if that body part is painful on use, you should be getting a compensable rating for that, even if it's just the minimum 10%.
Mm-hmm. A couple other CCK cases. We have Lyles v. Shulkin from 2017, which basically holds that evaluation of a knee disability under two different diagnostic codes for the knees, 5257 or 5261, does not preclude, so getting a rating under one of those codes does not preclude a separate evaluation for a meniscal disability of the same knee under a separate diagnostic code like 5258 or 5259. And the underpinning rationale for this holding was that a disability rating should factor in additional functional loss and should not be determined solely by a mechanical application of a given diagnostic criteria. I think what this is saying is what we've been saying this whole time, which is that if a veteran's condition is causing some type of functional impairment of some kind, the ratings that they get, and sometimes it might need to be accomplished by two ratings for the same body part that's disabled, that might be what needs to be done to meet that veteran's disability picture with the appropriate level of compensation. And I also read this as another reminder to VA, as we've been saying all along, to not just rigidly stick to the diagnostic codes for the source of what a compensation picture should look like for a disabled veteran with an orthopedic condition, because of all of these variables we've been talking about, because of performance of the joint and, weight bearing and not weight bearing, and trying to simulate real life conditions that the person would be in and be suffering because of pain or other limitation of motion. And then I think a little bit similarly, with respect to a more holistic approach, I think, of the disability and what it poses, we have Chavez versus McDonough from 2021. And this case talks about the application of 4.40 and 4.45, those regulations we talked about in the beginning that stress the importance of examining the conditions under which a disabled joint is functioning. These two regulations permit consideration under the general rating formula of an evaluation based on ankylosis if a claimant's functional loss is consistent with that contemplated by ankylosis, or in other words, if it's the functional equivalent of ankylosis.
Yeah, I think Chavez is one of my favorite cases because it really so I guess as a little bit of background, ankylosis is it's a medical term for when a given joint is locked in place, essentially. So just totally immobilized. So the court is saying, even if you don't have ankylosis, if you're like, the medical diagnosis of ankylosis, if your knee hurts so badly and is so weak that you literally can't use it or it'll just give out, that functionally that's, just as if that might even be worse than, but functionally it's as if you just cannot use it at all. So the recognition by the court here that you do not need this medical, condition in order to have the functional equivalent of it. It's kind of just like the next step in acknowledging you don't need to have flexion limited to X degree. You don't need to have ankylosis. You need to have impairment in whatever manifestation that comes.
Exactly.
And so another favorite case of mine actually is called Sharp v. Shulkin, and that deals with flare-ups. And I use them a lot together because especially when I have a veteran, I open up their file and I see, at the examination, he says, yeah, today, I'm not having a flare-up or anything, but there's days where I just wake up and I can't move at all. I can't even get out of bed. I just have to lay in bed all day. So that's a lay person's description of just complete immobility, complete inability to use, whatever the body part at issue is. But because he went into the exam that day and did not have one of those flare-ups, the examiner says, oh, well, they had full range of motion in their back. And so they just get, some low rating or non-compensable rating. So Sharp was the court stepping in saying, no, you need to, include flare-ups, reports of flare-ups, including estimates of how those flare-ups impact something in the examination requests, in the examination reports. And again, that's because when you have a flare-up, you have a given level of impairment. We're trying to compensate for what your impairment is when you're out there in the world. So, just because you're not in the VA examiner's room having one of those flare-ups, we need to know how that impacts you. So taken together, Sharp and Chavez, I think, are two of my favorites. Another one that we use a lot, or that we deal with a lot, it's actually from the federal circuit. So the court above the court of veterans claims, called Thompson v. McDonald. And basically what that says is that section 4.40, the regulation that's telling VA how it should consider these various manifestations, it's saying you can't get a separate rating under 4.40. You should have your rating based on the diagnostic code, in VA's regulation that has those range of motion, but it's just hammering home, you're getting it under that same range of motion diagnostic code. 4.40 is just there to tell us, do you have the functional equivalent of the ranges of motion in those diagnostic codes? So again, sometimes that one comes to me as like did we need a court telling us that? I guess so. Two people litigated that all the way through. So the answer is yes, but yeah, that one in particular, I think just kind of stresses what the court's been saying since the 90s at that point.
Exactly. And I'll end with one more that echoes a lot of those same sentiments and kind of makes me wonder, like, do we need a whole opinion from the court explaining this? Lyles v. Wilkie from 2017 is one of my personal favorites. This case talks a lot about functional loss, what it means, and how it's to be considered with rating orthopedic conditions. And the part that I think will resonate, hopefully, is that under 4.40, 4.45, and 4.59, which again are those regulations that set the guardrails of putting range of motion measurements into context and in connection with how a person's joint is performing. This case says that an adjudicator, so a rater at VA, may craft in recognition of and deference to the foregoing regulations, so those regulations I listed, a higher evaluation than would otherwise be supported by mechanical application of a given diagnostic code. So again, this is really the tension with ortho cases, which makes them complicated, detailed, and also something that we spend a lot of time working on. The court is saying in Lyles that an adjudicator can give a rating higher than that which is contemplated if you just plug in the veteran's range of motion measurements from the exam. They can do that by considering all of those other factors that we've been talking about. What's the functional impact of the joint? Where is their pain? Yes, they can achieve 45 degrees of extension, let's say, hypothetically, but what is the quality of that extension? What is that movement really like? Is it super slow? Does the knee become locked at a certain point? Is there a flare-up that happens once a day that results in even more impeded motion? So all those things need to be considered when fashioning a rating. And I think one of the reasons why this is so tricky is because I don't see VA doing this consistently. I remember, and you probably have the same experience, Nick, these cases are great in court because we can almost always find something wrong with either the exam or the way that VA evaluated a veteran's joint condition or orthopedic condition. But then when the case gets remanded back from court and goes back to the regional office for more development, I just don't always see the adjudicators at the regional offices doing this interpretation of the regs alongside the cases, alongside the diagnostic codes. I often see VA defaulting to, what does the diagnostic code say? What were the range of motion measurements? Boom, there's the rating. And that's really the problem that keeps resurfacing in these cases. And I think it's why we spend so much time on them.
Yeah. And I think it's an example too of those cases where, again, like as attorneys, our role or our goal is to get our clients, the maximum compensation that they should be entitled to. And sometimes we have these cases where he has a full or mostly full range of motion in his knee, even though it very clearly impairs him. So should we spend our time fighting with VA to get him from the 20% to 30 for the knee? Or should we focus on getting TDIU? And, once you have TDIU, even if your individual ratings, as we talked about earlier, are only whatever percentages, you're still going to be at least getting that maximum compensation. So, yeah, it's one of those cases where you just have to hold VA's feet to the fire. And I guess that's the benefit of getting these cases that sometimes sound like they might be saying the same thing that the court was saying in the 90s with, ever increasingly direct language. But yeah, at the end of the day, we're still at a point where getting the regulations, what VA should be doing, and what they are doing on the ground to match, it's still pretty hard. So I guess that's kind of where we come in and just, to strategize, okay, what's the best? You should be getting higher schedular rating for the knee, but is that practical? Is VA going to do that? What's the best way to just get you what you need at the end of the day?
Exactly. And that's so true of our practice. And that's a perfect segue into talking about some other related benefits or claims that can come along with a service-connected orthopedic or musculoskeletal issue. Because Nick is right. Sometimes the pursuit is to get an increased rating for the orthopedic condition, but that's not going to be the end game because that can be really, really challenging to do. And if you're in a situation or a pattern where the adjudicator is so fixated on range of motion measurements and isn't giving due credit or thought to the other indicators of functional loss and pain, you might be banging your head against the wall for a really long time trying to get that increased rating. So we always are being creative about what other options are available to get this veteran increased compensation if the IR ortho path fails. One of the things that we think about because of the experience that we have in the volume of cases that we've handled, we look at secondary conditions. So if there's a back disability, that's a big place to start. A back condition many times can cause lower extremity pain, numbness, things like sciatica. The same is true of a cervical spine condition. It can affect the upper extremities. So if we are pursuing IR ortho for a veteran's back condition, we're also looking at whether the lower extremities are affected. Is there a diagnosis? Are there symptoms in the lower extremities? Have they been claimed before? And if not, are those pathways for us to increase the veterans rating? You mentioned too, Nick, TDIU as being another alternative path to higher compensation.
Yeah, so there are two cases, Rice v. Shinseki and Harper v. Wilkie. These two cases basically stand for the proposition that TDIU is part of any increased rating claim when the evidence suggests unemployability.
Mm-hmm.
So again, if you are trying to get that rating higher than 10 or 20 for your knee and VA's denying that, if, in the examination report, it's your reports of how, no, it's really bad. I had to stop working. I couldn't walk around the factory floor all day anymore. That is, or should be, VA's cue to say, okay, well, even if you don't get higher than 20 on a schedular basis for that knee, that's evidence that you can't work. So we need to also just adjudicate whether you are entitled to TDIU.
Mm-hmm.
So kind of, we'll get a lot of cases where even though VA does deny higher than 10 or 20, they also grant TDIU. And, usually in that case that, it's a good decision where they went through and they saw that. They don't often sometimes they'll miss evidence or not recognize that evidence raises it.
Mm-hmm.
So yeah, that's a common one that we look for
mm-hmm.
when we do have these ortho cases.
Mm-hmm. And other avenues to increase ratings, I'll cover a few at once. I'll talk about special monthly compensation. This list is not meant to be exhaustive. We have a lot of other resources on special monthly compensation, but sometimes SMC can come into play if you do have an orthopedic condition. Special monthly compensation is meant to compensate for extraordinary effects of disability that go beyond that which is contemplated by the standard 0 to 100 rating schedule. So a couple of types that could be in play. There's SMC-L, which includes special monthly compensation based on the regular need for the aid and attendance of another person. So if you have an orthopedic condition like a severe back injury or a knee injury, you might have trouble completing activities of daily living, like toileting, bathing, feeding yourself, think upper extremity conditions that would prevent that. So SMC might be an ancillary benefit that's on the table. Important to note, and we've said this a million times, and VA still gets it wrong, you do not need a separate claim form for SMC. Like with TDIU, it's part and parcel of an increased rating issue.
Right.
So VA is supposed to consider it when it's raised. If you really are serious about getting SMC, though, you do need to flag it. You need to be very clear and explicit about your intention to seek those benefits. That's the path that I would go down, at least knowing that VA is very not always the best at intuiting what people are saying.
Yeah, it can be super hit or miss. I've seen, again, in my day-to-day, I only see sort of the worst of the worst. Sometimes when I've gone through screening and looking through cases that we may or may not identify, I see board decisions where they do just pull out all the stops and go through the SMC analysis and TDIU, and they award a lot of benefits. I like to see those. It's just, I wish I saw them more, because that's when I'm like, okay, I'm not going to appeal that one because, VA did its job there. It went through, the veteran didn't explicitly raise SMC, but they saw. That just seems to be more, the exception. Usually, especially with SMC, it's very much overlooked.
I think that's right. I think it VA will get it right, giving credit where it's due, just not with the level of consistency that we would like to see.
Consistency is the key.
Yeah.
That's where we come in, making sure that
exactly
if they don't in your case.
And then there's also SMC based on loss of use. So subsection M of the U.S. Code at 1114, and also in the regulations at section 3.350, talks about when loss of use of a foot or hand will be deemed to exist, and that's when no effective functioning remains, other than that which could be accomplished by amputation and basically the use of a prosthetic. That's a little bit complicated, but it is something that is worth thinking about. There are rules about amputation that we won't get specifically into, but suffice to say that there are regulations that do compensate and contemplate a veteran who does have physical loss of limb, hand, or foot. But then there's also, what does it mean to be effectively limited in use of your foot or hand such that you might need an amputation, but there's no amputation happening. The hand just remains with you and is not functional. So even in those instances, SMC might be on the table depending on the circumstances. And we mention it in this ortho segment because it's worth thinking about in connection with orthopedic conditions that could lead to that type of loss of use of effective functioning.
Yeah, I think for the loss of use specifically, probably the most common fact pattern that I've seen is when you're wheelchair bound. If you are service connected for both of your knees and, there's no medical reason to amputate the leg, but you just physically all you can do is get out of bed and move yourself to a wheelchair, and you have to use that wheelchair to ambulate. That is a good case where you very well may be entitled to SMC based on loss of use.
Exactly.
But yeah, so there are a lot of ways to potentially increase compensation. There are a couple limiting rules, which I don't want to get too much into, but just very quickly, there is the amputation rule, which basically just says, VA has diagnostic codes for amputations. So they have a diagnostic code for if you have to have an amputation above the knee. And I can't say I have the exact percentage off the top of my head, but whatever that percentage is, you can't get higher than that for your knee. So, you may be able to get multiple ratings for your knee for limitation of extension and flexion and for instability and maybe some additional manifestations if you had, your meniscus removed. All of those combined, they'll just cap them out at whatever the amputation rating would be. So that's just one thing to keep in mind. And the last one that I'll mention is the rule against pyramiding. And pyramiding is the term of art that they use for double compensating a single manifestation. So if you have a knee disability with two ratings, one for flexion, one for extension, that's not pyramiding because one is limiting your ability to extend your knee out, one limiting your ability to flex it. But if you have a single manifestation that could theoretically fall under multiple diagnostic codes, you can't get all of those. Again, the most common one that I see is usually when you have that section 4.59 minimum compensable rating based on pain. There, you're being compensated for your pain. So you can't be compensated for the pain on flexion and on extension because it's just pain. So you're just going to have your one rating. It's not until you have actual limitation that you would get multiple ratings. But those are just the two limiting rules that most often come into play. But yeah, for the most part, there are just a ton of different avenues for increasing your compensation. It's just a matter of figuring out which one works for you.
Exactly. And you want to be mindful, like we've talked about, of the regulations that are in place, the case law. You also, we didn't get too much into this, but you want to be thinking about how you're presenting for a compensation and pension exam when you know that range of motion measurements are going to be taken. And then finally, we would always advise to think about whether there are any secondary or related effects of an orthopedic condition, even up into or up through impairing the ability to work, loss of use of the joints, and things of that nature. So let's now segue into more questions from viewers. These kind of run the gamut of a bunch of different topics. They're all pretty complicated, so we have our work cut out for us.
All right, so one of the first questions that we have here regarding SMC-S, is there one VA form that allows you to apply for multiple special monthly compensation categories at once, or are there separate forms for each group? Maura, could you give us some insight on that?
This one's tricky because the first thing I want to say is that you do not need a specific form to claim SMC. If you want to file for special monthly compensation benefits, you would want to do that based on whatever claim form you would need to ask VA to consider giving you those benefits. Sometimes that's with a 526 easy form if you've never claimed the benefit before. Sometimes it's an 0995 supplemental claim form if you've been previously denied SMC, really at any level. Or sometimes you're just raising SMC in the context of an appeal. Let's say you file for an increased rating and you get denied. You want to appeal that determination and you also want to raise entitlement to SMC. You can do it within the confines of your appeal form too. There is a specific form that VA will ask you for if you're claiming benefits based on your need for the regular aid and attendance of another person, which is SMC at the L rate. And that's the 2680 form. This is a form that goes through what types of activities a veteran needs assistance with due to service-connected conditions. So if you get kickback from VA about that form, if you're claiming aid and attendance benefits, that's going to be why. So I would consider the 2680 for A&A, but then otherwise just express your intention to seek special monthly compensation benefits on whatever form you're needing to use to file for another claim or another appeal.
Right.
Nick, can someone recovering from surgery for a service-connected condition receive SMC-S during that period of time, knowing that SMC-S is meant to compensate for a housebound condition?
So short answer is yeah. So if you are in fact housebound while recovering from surgery, which is often the case, then you can definitely qualify for SMC-S while you have that convalescence period. But you can also actually qualify for SMC-S a different way as well. So one way to get SMC-S is to have a single disability rated at 100%, and then the rest of your disabilities combined to at least 60%. So if while you are in the convalescence period, you do have, let's just say your back rated at 100%, and then you do otherwise meet that 60%, then you just meet the mathematical formula for SMC-S during that period. So in that case, even if you were not strictly housebound, you could still meet it. So short answer, yes, you definitely can likely get SMC-S during the convalescence.
Great. And this is more of a hypothetical, but a common question about getting benefits that are related to obesity. That's a very complicated avenue that we won't go fully into. But hypothetically, if a veteran has a service-connected back injury and cannot exercise and is impeded in their ability to move, and that veteran consequently gains weight and develops type 2 diabetes, can that veteran get secondary service connection for diabetes? And if so, how?
Yeah, so you can get service connected on a secondary basis for a number of conditions. Type 2 diabetes as secondary to a condition with obesity as an intermediate step is a common one. So what you need to do, there are a couple steps along the path to show a nexus, which is what you always need to show for service connection. So you need to show that the service-connected condition, in this case your back, caused or contributed to becoming obese, and then that obesity caused or contributed to the development or aggravation of a condition, like in this case, type 2 diabetes. So just like with anything else, VA may have the duty to assist you in getting medical opinions, establishing that nexus. But those are the questions that will have to get answered in order to get service connected. But yeah, it's definitely a doable and fairly common way of getting secondary service connection.
And it's good to know because while obesity is not recognized as a standalone service-connected disability that there's a code for or anything like that, as Nick described, the relationship between a service-connected disability, obesity acting as an intermediate step, bridging that gap, unfortunately, to another condition can pave the way for secondary service connection.
Right. And so another question here, this is more pivoting back to TDIU. So the question is, do gifts count as income for purposes of entitlement to TDIU? So just as background, to qualify for TDIU, you can't make more than marginal income, which is set at the poverty threshold. So do gifts count towards reaching that income threshold?
This is a really interesting question. I've definitely seen it over the years in different kinds of contexts with TDIU, and it's hard to give a hard and fast answer. I think for the most part, most gifts are not going to qualify as earned income. And they're also not going to necessarily preclude your ability to qualify for TDIU, because TDIU is about whether you have service-connected conditions that preclude your ability to obtain or maintain substantially gainful employment. So receipt of a gift is not evidence that you can work, especially when you have service-related conditions that would otherwise impede your ability to show up for a job or perform the duties of a job within your educational and vocational experience. A couple things that I would consider, though, is for income purposes, I think about how do we prove to VA that a veteran does not have substantially gainful income. And that requires showing that the veteran is either receiving no income or has merely marginal income, which is that which is defined as below the poverty level threshold for a single individual.
Right.
So if you're receiving a gift that's more tantamount to like passive income, where it would be showing up on tax documents or your Social Security earnings records, that's going to be a problem. So It's almost like gift status is an aside from what really matters for VA, which is what is your documented earnings? What are the earnings that you're capable of? So even thinking about a situation where someone is like receiving income, but it's under the table and not reported, that is still relevant in a TDIU assessment. So I hate to give you the lawyerly, it depends answer, but I think the real focus for income should be on how VA otherwise defines what that means. And typically, if you're gifted a car or a house or a check or something, that is not going to be showing up as income for TDIU purposes, very generally speaking.
Right. Yeah, I think it just seems to be VA's practice oftentimes, in my experience, to go by Social Security earnings. So definitely you're going to want to talk to somebody if you're dealing with passive income or gifts. But that can be a good baseline to start as what is, as far as the Social Security Administration is concerned, your income level, just as a starting point.
Exactly.
But yeah,
Great advice. And we will pick up with some more questions to answer in our next podcast episode. Many of these questions come from the comments on our YouTube videos. So if you have a question, please feel free to leave it there. And we hope to be able to answer it for you next time. Thank you so much for listening to the Veterans Legal Lowdown today. We've covered a lot. We've talked about special monthly compensation, clear and unmistakable error, TDIU, extraschedular TDIU, how we work IR ortho cases. And so we hope all this information was helpful to you. If you learned something today, please be sure to like and subscribe on YouTube and follow us wherever you get your podcasts, Spotify, Apple Podcasts, or elsewhere. And remember, as always, take care of yourselves, take care of each other, and keep the fight alive. Thanks.